So the title of the show is the problems with your trust. You know, and there's obviously we're stressing your, not mine, or the trust of my family estate. I'm talking about your trust. Now, what I'm about to say may be, widely known. I doubt it is, though. I waxed poetic about this stuff for 5 years almost. The bottom line is this. There's two main different types of trust. You got a trust that owes its existence to legislation, state legislation. It's a trust agreement. And you have a trust contract. One is public, one is private. One is public, one could be public. You can have a private trust contract executed and still be public. How? It's due to language. It can be due to lack of understanding. It can be due to lack of knowledge. It can be due to lack of proper administration. It could be due to a number of things. But I'm going to go over the reasons why I'm pretty sure why your trust has problems. Now, problems can be addressed, problems can be fixed. I invite you to email me, admin@welcometothefoundation.com. I can help you fix your problems. You can get into trustee training. There's so many trustees. They've had to dissolve their trust, amend their trust. They come into trustee training, and once they get the proper education, they realize the problem with their trust. So let's get started. The state governs your trust, number one. Oh, no, so I got a private trust, yep. No, it's contract, yep. Oh, it says it's not governed by the Article 1 jurisdictions, quasi-tribunals, yep. It says in the contract, yep. No state can pass any law impairing the obligation of the contract, yep. All these things I've heard. All these things don't matter. Because as I said before, without proper administration, it will come under state jurisdiction. Why am I so confident? I've seen it many times. I've read a lot of court cases. I've seen it many times. Most all information you get your hands on with regards to administering a trust is coming from the public. It's going to be coming from statutes, state statutes, some person's interpretation or limited understanding of state statutes, state educated attorneys and lawyers, or some sort of, boilerplate PDF that was put together by Willie Bobo, who didn't really know, and he just straight choked on the proper, expression of the jurisdiction in the contract. That's what it breaks down to. Now, there is specific language that can be invoked in the contract itself to remove it or ensure, not even remove, but to ensure that it never comes under what we know as statutory jurisdiction. But I've never seen it in the public. Never, not once. Not one time. I've seen stuff that tried. I've seen stuff that sounded good if you didn't study law or jurisprudence. But I've never seen it. So that's a problem with your trust. It's governed by the state. That's problem number one with trust. It's governed by the state. Problem number two is that you don't even know it. All right? What's the first problem with your trust? It's governed by the state. Second problem with your trust, you don't know it. You don't even know it. You won't know it until some sort of action or audit or something like that rears its ugly head, and at that point, it's really too late. What we know is that it is a rare occasion where, a private trust properly administered is brought into the public pending like any type of litigation or jurisdiction. Jurisdiction isn't met. The state is at want for jurisdiction when it comes to properly administered trusts. I'm going to read something, but before I do, I want to explain. You don't know the difference between a trust agreement and a trust contract. So look, contract. Come on. A contract is an agreement which creates an obligation. Its essentials are competent parties, subject matter, a legal consideration, mutuality of agreement, and mutuality of obligation. So when you go to the lawyer to have them draw up your trust, that means you're incompetent. You're not competent to draw up your own trust. That's why the lawyer's drawing up the trust, the inter vivos trust. So it doesn't fit the terms of a contract. You understand what I'm saying? I know. I'm sorry. I know. Ouch. It's simple, though. I'm reading from an American jurisprudence on contracts. A contract is an agreement which creates an obligation. Its essentials are competent parties, subject matter, a legal consideration, mutuality of agreement, and mutuality of obligation. That's from Denver Truck Exchange versus Perryman. Supreme Court citation. So competent parties. Are you competent if you have to have a lawyer or an attorney draw up your trust? Come on, let's get into this. What law governs? There is said to be conflict and confusion. In cases dealing with the determination of the law that governing contracts, contracts governed by foreign law may be recognized and enforced under the doctrine of comity, amity, and commerce. The extent to which this is done being a matter for each jurisdiction to determine. When the courts have been faced with the necessity of selecting the law to be applied as governing a contract, they have had several factors to consider. First, there is the intention of the parties, which in the construction of contracts generally is always sought to be ascertained. So when you construct a contract, the intention of the parties must be ascertained. When a trust agreement is constructed for you because you are incompetent in such matters, it is not a contract. It is merely an agreement that is allowed by the state. Second, There's the place where the contract was made or entered into. Third, the place where the contract is to be performed. It has been said that in the infinite variety of circumstances presenting choice of law problems relating to contracts, it is safe to say that there is no simple and dependable rule of thumb by which the choice may be unerringly made. And the cases dealing with this subject have been said to be in irreconcilable conflict and hopeless confusion. This is undoubtedly true to all matters concerning the contract, except as to the remedy and procedure involved. It is almost always governed by the law of the place where the suit involving the contract is brought, or the lex fori. So basically they're saying if Wells Fargo sues the trust in Article 1 court, it's almost always governed by the law of the place where the suit involved in the contract is brought. So are they suing under the contract itself, the trust, or under the contract that you entered into on behalf of the trustee with regards to banking? And is there an overdraft fee or something like that? It's private. Wells Fargo, there's no jurisdiction in the Article 1 court, and you get steamrolled because you don't understand you as a fiduciary of the trust, you have the ability to bind the trust, which means you contracted the trust into that jurisdiction by signing the documents for the bank. That's why you lost. That's why you lost the case. An examination of the opinions reveals apparently inconsistent statements in the same jurisdictions and even in the same cases, much of which is dicta, and hence care must be exercised in determining the rules enforced in particular jurisdictions to differentiate between the rules as announced generally and the actual application of the rules. It has been stated that the law which will sustain rather than that which will defeat a plain and fair agreement should, where possible, be applied. Once again, it has been stated that the law which will sustain rather than which will defeat a plain and fair agreement, where possible, be applied. It is ordinarily to be applied that parties who have purportedly entered into a contract intended to the agreement to be legally effective, and this implication has been frequently resorted to in the setting questions of conflicts of laws. The law of the state determines the effect of a written instrument, also governs its construction. Okay? So the law of the state, which determines the effect of the written instrument, governs its construction. The mere fact that the instrument is a contract does not mean that the conflict rules to be applied are those associated with contract, but rather may be and most likely would be those associated with the jural relations directly affected by provisions of the agreement. It has been stated that the nature and effect of a contract are governed by the law of the place with reference to which it is made. That rights and obligations under a contract are governed by the law of the state with a view to which it is made, and that the law of the form which governs performance under contract must be applied in questions arising from the alleged breach thereof. The lex fora has been said to embrace the whole of the residuum, which cannot be referred to other laws, to determine when and how foreign laws are to be adopted, and it's applied to applicatory law in all cases except with respect to interpretation in the mode of solemnization or performance. So look, there's a lot being said. A lot being said. Bottom line, what is the jurisdiction that your contract or your trust falls under? The laws of the states which determines the effect of a written instrument also governs its construction. So if a state can determine the effect of the trust, then it governs its construction. You follow what I'm saying? I hope you follow what I'm saying. Because if a state can determine the effect of your trust, then the state governs and determines its construction. So in many situations, in many cases, most people are trying to execute and express a trust where the state has no effect in determination in determining or determination in the written agreement. So therefore does not govern its construction. So therefore does not govern its administration. So that we may administer entities that are not created and governed by the state. See, business was happening. People were doing business. Merchants were traveling. Circuses were coming into town. This stuff has been going on for a long time before the state of Nevada got here, or the state of Kentucky, or the state of Texas. And these is, it's just a state of. You ever been in a state of shock or a state of joy? State of mourning? A state of Kentucky. Not Kentucky, a state of Kentucky. Very interesting. So, if you don't or aren't really able to, understand what I'm trying to get at right now, you might want to consider trustee training, or at the very least, go to welcometothefoundation.com and grab the trust primer. If foreign law governs the contract, such law must be pleaded and proved, and on failure to do so, the law of the forum may be applied, or the common law thereof, if the foreign jurisdiction involved is a common law jurisdiction. When, however, the common law has never been enforced in the place where the contract was made and the foreign law is not proved, the court will follow the law of the forum. So you got to prove the foreign law. What is the foreign law? You got to plead. Look, if foreign law governs the contract, so if you're saying law outside of the state governs the contract, such law must be pleaded and proved. And on failure to do so, the law of the forum may be applied. What is the foreign law? What is the foreign law that governs your private contract, your private trust? What is the foreign law that governs it? Some people say, oh, it's the common law. Nope, it's not the common law. Common law does not govern the trust contract. The contract exists due to the people's right to contract unlimited. So because you can contract unlimited, you can create a contract. That's a common law right. That doesn't mean the common law governs it. The common law is not the foreign law. That's why it says here, on failure to do so, the law of the forum may be applied, or the common law. So they're saying the foreign law, the law of the forum, or the common law. So what's the foreign law that governs your trust? A lot of people don't know. Am I going to say it on the air? No. I'm not. There'll be a lot of speculation. People will say Jamaica. People will say some weird island off somewhere. It's not. I will tell you off the bat, that's not it. 100%. It's so simple, too. So simple. So simple, you're like, what? Contracts made in or governed by the law of a foreign jurisdiction are recognized and enforced because of comity, but not as a matter of right. Since the law of one state has proprio vigor, no force or authority beyond the jurisdiction of its own courts, comity is overruled by positive law. And it is left to each state or nation to say how far it will be recognized and to what extent it will be permitted to control its own laws. In some instances, the enforcement of a foreign contract or the recognition of the lex loci contractus has been regarded as a matter of common justice. It's a matter of common justice. In some instances, the enforcement of a foreign contract is in some instances regarded as a matter of common justice. What's the foreign law? Does it say it in your trust? That's what's wrong with your trust. That's a problem. That's a problem. That's one of the problems with your trust. What's the foreign law? If it's not the state law, if it's not statutory law, what's the foreign law? By the way, contract made in or governed by. Oh, my bad. I'm sorry. That's not what I wanted. When, however, the common law has never been enforced in the place where the contract was made, I'm looking at you, Louisiana. Common law was never enforced there. Napoleonic law, civil law. You don't know the foreign law. What's the foreign law? What's the foreign law that governs the contract? You don't know the foreign law that governs the contract. And if it isn't a foreign law, then that's a problem with your trust. Let me start wrapping this up. You don't know what adverse trustee is. You don't know what adverse trustee is. That's a problem with your trust. It's another problem with your trust. You don't know what adverse trustee is. That's a problem. You got a problem. But with the adverse trustee, I'm just going to do this. An adverse trustee or an adverse person is one that, a trustee that owns some trust capital units or beneficial interest, has some sort of beneficial interest in the trust, even if by executing your trust duties, the contract stipulates that you have some sort of benefits, okay? Then that's you, right? So anyone who has some beneficial interest in the trust or any beneficial units who would be adversely affected by the exercise or non-exercise of a power which they possess with respect to the trust. So if you're supposed to do something and you don't do it, or if you do something and it harms, so like let's say we're both trustees. You and I are both trustees, right? And one of the benefits of us being trustees is we get reimbursement on transportation costs, right? But let's say you go and use, as a trustee, you go and use all of the the trust funds. Let's just say, for this example, all of the cash available to buy a ticket for you to fly somewhere. I'm an adverse trustee because if you took all the money out of the trust and bought a flight, then and there was no more money left over to reimburse me for my travel, then that would have adversely affected me. Your exercise of your power adversely affected me. You did have a power to do that. You have a power to, do what you do. If you're a signer on a trust account at the bank, you have the power. You have the power to commingle or self-deal. You definitely have that power. And, if I'm adversely affected or a beneficiary is adversely affected, that makes me an adverse trustee. So, I guess that was a problem with your trust, that you didn't know what the adverse trustee was, but now you know what adverse trustee is, I hope. I trust that you do. Why do you need an adverse trustee? You can't be the only trustee, man, of a trust, man. It's difficult. It's difficult. There must be someone that exists that would be adversely affected if you exercise or didn't exercise, if you didn't do something you're supposed to do or you did something that you weren't supposed to do. It would adversely affect someone else's position or whatever. There has to be someone else. There has to be someone else. You can't just be the only trustee. That's why. The problem with your trust is you're the only trustee. That's the problem. There's no adverse trustee. That's the problem with your trust. Straight up. I'm not even trying to, not even trying to start none. I'm trying to help you. What's another problem with your trust? It's an agreement authorized by the state. You understand what that means now? If you went to an attorney and the attorney set up your trust, it's an inter vivos trust. It's what is known as a grantor trust. It protects you from probate, but it does not protect you from creditors and litigation or even a bankruptcy. Whereas, a private contract set up properly, administered properly, does protect from all those things. It's, it's state. Man. It's just one of those things. So, I know it hurts. I'm not trying to, hurt anyone. I'm not trying to upset anyone. I'm just trying, I'm trying to help you out. I'm trying to tell you the problems with your trust. And you may not have these issues. You may not have these problems with your trust. But another problem with your trust, it's not a contract. It's not. It's an agreement. There's a difference between a trust contract and a trust agreement. A trust agreement is typically going to be governed by the state, hands down. It's going to come under statutory jurisdiction. A trust contract, properly executed with the proper jurisdiction invoked and proper administration, does not come under state jurisdiction. It just doesn't. It's not how it works. And people think, oh, I got my 9A number, I got my trust, I'm good. No, you got to know how to administer it. Just having a trust, even if it's set up properly, doesn't mean anything unless you administer the trust properly. You don't self-deal. You don't commingle. And you do the things necessary to protect the trust entity. Yeah, otherwise, it means nothing. It means nothing. And then, I got people who are so mad, so upset because they feel like they were railroaded and their rights weren't recognized and all these other things, and really you don't even know how to administer a trust. So they're taxing everything to you individually. They're charging you interest and penalties and fees. You already paid Guru Boo Boo the Foo Foo $12,000 or I don't know, whatever, to set up your trust estate or give you the contracts or whatever. And dude don't want to he don't properly want to educate you properly. He doesn't want to do that. He wants to get mad at you when you ask him questions and yell at you and stuff and make you feel stupid. So instead of asking questions and getting answers, you didn't, because you didn't want to get embarrassed. You were just out there doing what you thought was your proper dance, and then you got audited. And you can't get a hold of Guru Boo Boo the Foo-Foo who used to scream at you. And most people always, they always blame the trust. The contract might have been perfect. 9 times out of 10, it's the administration. Some sort of faulty, laxed, or improper administration. What's the problem with your trust? It's not a contract. Some will scramble and attempt to find wording and amend their trust or go with their ego and believe they can do it on their own. Some may believe that they don't need any help. And, may have the mind state, hey, I've got myself this far, I can figure it out. That's ouch face. Ouch face and neck. It's different when you're learning to ride a bike. I like this analogy because I don't know. A, it brings me back, and then B, I think everyone has learned how to ride a bike at some point in their life, so you can kind of relate to it. But when you learn how to ride a bike and you fall off and you scrape your knee, right, or your leg or whatever, and then after a few days it scabs over and then it heals and it goes away. Well, when you're learning how to administer trust and you fall down, instead of scraping off some of the skin from your knee, you're scraping money off. Just money's getting scraped. Money's getting scraped out of your estate. Wealth is being scraped away from you when you fall off that trust bike. Taxes, penalties, fees, interest, scraped. And money doesn't heal like skin does. You can't just chill and just relax and just watch some TV and stuff and just take it easy. And your money just come back. That's not what happens. Your wealth doesn't come back, just like your time doesn't come back. So, having that belief that, I can figure it out, I can do it, hey, that's a tough scrape to take if you're wrong. And it's a small price to pay to continue to educate yourself. People who are wealthy, you don't have to tell them. You offer it to them and they grab it because they know. Wealthy people know that most of them got wealthy, became wealthy, or stayed wealthy due to what they learned, the knowledge that they have, the knowledge that they acquired, whether it's through multiple books or mentorships or videos or whatever it is. It's private education. And, I say private education, I think people automatically think trustee training or learning how to administer trust or something like that, where private education is way more than that. Way more than that. Private education basically means what's not taught in schools. And, doesn't necessarily mean that it's a good private education. It can be private and be terrible. Just straight terrible. But, wealthy people know that the best investment they can make is in themselves. And the best way to invest in yourself is to take care of your health and to gain as much knowledge as you can, to invest in as much knowledge as you can. That's how we invest in ourselves. And we invest in our private educations. And, I was just trying to tell you some problems with your trust. I'm not trying to call out anything. I'm not trying to call out anyone. I'm not trying or attempting to shame anyone or belittle anyone or, son anyone or make anyone feel stupid. We all make mistakes. It's really just that. We all make mistakes. Really, what it is what do we do after we make those mistakes? Do we get up and correct and do right and figure it out? Or do we lay down and cry, baby? Lay down and cry, baby. And accept the conditions of failure long term. You think that's what it is? I don't think that's what it is. I think as we fail, we learn from our failures and we move forward. And some of you've already, quote, invested in your private education, and it didn't work out so well. And I invite you to email me, admin@welcometothefoundation.com, and invest more in your private education, but correctly. Because incorrect information incorrectly applied can get you hurt. And correct information incorrectly applied can get you hurt. And that's what we know here at the foundation. So what are the problems with your trust? I could have missed a bunch of things. Haven't talked about how I've seen, crafters of trust that are sold for profit attempt to describe and express jurisdiction. Man, it's sad sometimes. Might be the jurisdiction that's invoked in your contract. You might have a private contract. I don't know. The problem with your trust might be jurisdiction. The problem with your trust may well be the administrator's. Problem with your trust may be one of the trustees. You got the wrong trustee. Problem with your trust may be the lack of substantiation. The problem with your trust may be the lack of proper education of the Board of Trustees to make substantive, proper moves to advance, grow, create wealth, and enhance the wealth of the private estate. And when we're talking about a private estate, we're talking multi-generational wealth. Multi-generational wealth is at least 300 years. So, what is that? At least 4 generations? That's multi-generational wealth. And I don't know. I guess for me, that's the goal. Maybe for you, it's a different goal. Maybe for you, I don't know. Maybe it's something that I can't even fathom. I can't even understand. But either way, I just, I hope this show went far enough to assist at least in helping those realize that, it says episode ended. And if it did, dang. If it did, I wasn't ready. If it didn't, I'm just going to wrap up. I appreciate y'all checking out the show. Make sure you email me, admin@welcometothefoundation.com. You know what I'm saying? Y'all have a great week. I will catch you next year. Happy commercial new year. Y'all have a great one. Peace to the guys.